Welcome to Manik YouTube class for Civil Service Examination. We shall be starting from the class that we concluded last class from budget. We have already discussed the stages of budget and we were discussing demand for grants. And as I told you, demand for grants are made in the Lok Sabha only. It is related to passage of demands and approval of the Lok Sabha on such demands make it grant, and demand for grants are exclusive privilege of the Lok Sabha. During the demand for grants, the oppositions move the different court motions. We were discussing that court motions, and there are different type of court motions like policy court motion. So first we shall discuss policy court. This court motion shows disapproval of policy underlying a demand. Here the opposition is concerned about the content of the policy underlying the demand, and when policy court motion is passed or approved, it will amount to the end of the policy or end of the demand or the end of the scheme. That is, the members can also advocate alternative policy if such demand, for example, Beti Bachao Beti Padhao Abhiyan. If the opposition does not agree with the underlying policy of the scheme, then it will move the policy court motion, and if policy court motion is approved, that scheme will be replaced and or maybe taken away or may be replaced with a new alternative policy. That is called policy court motions, and the allocation on the budgetary allocation on the scheme will be reduced to rupees 1. If the policy court motion is approved, then it will, the amount on the allocated on the fund or on the scheme will be reduced to rupees 1. That is also a point, policy cut. Okay, so that is show disapproval of the policy, and if the policy is reduced, it will reduce to rupees 1. Amount of the demand shall be reduced to rupees 1. That is called policy court motions. Then economy court motion. Economy court motion. In economy court motion, the major emphasis is on the amount that is allocated on the fund, that is expenditures. It states that the amount of the demand be reduced by a specified amount, the amount on the scheme. So that is emphasis on reduction on the budgetary amount on a demand. Here the opposition is not in disagreement with the policy underlying the scheme, rather the motion is against the demand or the amount of money that is allocated on the demand. The movers of the court motion want the amount to be reduced by a specific amount, and it is reduced by, if it is passed, it is reduced by a lump sum. By a lump sum. It is reduced by a lump sum. That is called the budgetary allocation is reduced by a lump sum in economy court. So it is a type of court that is related to expenditure or the money that is allocated on the scheme. That is economy court. Then the last court, that is token court. In this court, there is a disagreement it ventilates a specific grievance, that is the motion is moved to show disagreement with certain aspects of a given demand. The entire policy or the entire demand is not in problem, but some parts of the demand, some aspects of a policy are not considered acceptable by the opposition. Hence, the token court is introduced, and if the token court is approved, then it is reduced by rupees. Symbolical reduction is reduced by rupees 100. Rupees 100 symbolically cut. That is called the rupees 100. Rupees 100 is cut from the amount. So token cut is a symbolical cut. These are the three types of cut motions that are moved in the parliament during the passage of the budget, especially by the opposition. Remember, cut motions should be specifically is moved on a particular demand, not on more demands or a number of demands at a time. It should be issued on a particular demand. It should be issue specific. There cannot be any amendments through the cut motion. There cannot be any amendments or repeals in the cut motions. Okay, and cut motions are usually that is moved by the opposition, and if they are passed, they usually show the lack of confidence, lack of majority of the ruling party. It seldom happens because ruling party has a majority in the Lok Sabha. But cut motions are that are a financial control mechanism of the parliament over the executive. It shows the disapproval of the opposition or of the parliament against anything that government is involved. Therefore, cut motions are essential instrument of financial control in a parliamentary democracy. Whether they are passed or not doesn't matter. They are the symbol, they are the strength of parliament, and they can be used. Frequent use should be there, and during cut motions discussions are take place invariably on the specific demands. So they are very essential in our system, that is cut motions. All right. So cut motions are of three types, as we have noticed, and they are essentially required in a parliamentary democracy. It is an effective measures, and cut motions should not raise a question of privilege also, and it should not reflect on the character or conduct of any person whose conduct can only be challenged on a substantive motions. It should be not anticipate a matter which has been previously appointed for consideration in the same region, and it should not relate to matter that is under adjudication by a court. So there are various restrictions are there on a cut motions. They are essentially put. The significance of cut motions lies in facilitating initiation of concentrated discussion on a specific demand, and it upholds the principle of responsible government by probing the activities of the government. However, the cut motions do not have much utility in practice. They are only moved and discussed in the House, but not passed, as the government enjoys majority support. So I am reading from a prescribed book. Their passage by the Lok Sabha amounts to the expression of want of parliamentary confidence in the government and may lead to the resignation. On the last day of the days allotted for discussion and voting on the demands for grants, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. So guillotine is also adopted in the things. So this is all about your cut motions, and then passing of appropriation bill, passing of appropriation bill that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Accordingly, appropriation bill is introduced in Parliament, and after the passage of appropriation bill, the amount that is the budgetary amount that are provided will be credited to the government, and government will be in a position to spend the money after the passage of appropriation bill. So appropriation bills becomes appropriation act after it is assented by the President. This act authorizes the payment from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India until the appropriation bill is approved by the Parliament. So that is also a point to be remembered. Is introduced to provide for the appropriation of the Consolidated Fund of India. So that is a major things, and it is the last stage, invariably almost the last stage. And then financial bills are passed. They cover the income side of the government, and it takes several days to have been passed by the Parliament. So finance bill is ultimately held in the last stage, but after the passage of Appropriation Act, this goes to the government. Government now able to withdraw the money, budgetary money from the Consolidated Fund of India. So that is a major thing that takes place. So we have discussed the three stages. Remember, the last stage is financial bill, passing of the finance bill to give it the financial proposal of the government. And according to the Provision Collection of Taxes Act 1931, finance bill must be enacted within 75 days. According to the Provisional Collection of Taxes Act 1938, the Financial Act legalizes the income side of the budget and completes the process of the enactment of budgets. So these are called your budget in Parliament. So after the budget is passed, now government is able to draw. Next, apart from the budget, there are also certain grants issued by the Parliament or passed by the Parliament for the government apart from the budget. So simultaneously, there are some some grants are allotted by the Parliament. That is a supplementary grant. One is supplementary grant. Remember, supplementary grant is passed by Parliament through an Appropriation Act to supplement the insufficient fund in a given scheme or in a given program in the budget. If the money is insufficient, it is seen after passage of the budget, after implementation of the scheme, if money is insufficient because of excess expenditure, because of expenditure more than expected, then the Parliament will pass a supplementary act to enable the government to draw the excess money from the Consolidated Fund of India. Then we have additional grant for new services. The additional grants need has been endured during the current financial year for additional expenditure upon some new services not contemplated in the budget. Additional grants are made to meet the expenditure for some new services attached to any related services or attached to any scheme, that new services which were not conceived in the budget. So that is called additional grants. Then some excess grants is provided also. It is granted when money has been spent on any service during a financial year in excess of the amount granted for that services in the budget for that year. It is voted by Lok Sabha after the financial year. Before the demands for excess grants are submitted to Lok Sabha for voting, they must be approved by Public Accounts Committee of the Parliament. So excess grants are approved later after the passage of the budget to meet the excess expenditure occurred on a particular implementation on a particular scheme or programs, and that must be approved by the Public Account Committee of Parliament. Then vote of credit is another there, vote of credit. Vote of credit is given for meeting an unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service, the demand cannot be stated with details ordinary given in the budget. Hence, it is like a blank check. So, vote of credit is given on a scheme or on a project whose prior estimation is not possible due to the nature or the magnitude of the work. So, the prior estimation cannot be estimated properly, cannot be properly calculated. Hence, a blank check is provided, or hence no amount is specified in the grant, and this is why it is called a blank check on the government. It is called blank check on the government, that is called vote of check and given to the executive. Then some exceptional grants are provided, granted for special purposes, forms no part of the current service of the financial year. And another is token grant. Token grant is just money is diverted from one scheme to another. If the money granted on that scheme is not spent or is not being released because the scheme is the scheme is not being implemented, or if the scheme is withdrawn, then the money allotted on the scheme may be diverted to any new scheme, and that is done through passage of token grants. So, here the money is appropriated for reappropriated for other schemes, for new schemes or for other schemes, but the money was granted for a particular scheme, but the scheme is not implemented now. So, the government wants to divert the money from one scheme to another, and that is called reappropriation. So, in case of reappropriation, a demand for the grant of a token sum of rupees 1 is submitted to the vote of the Lok Sabha. If assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve additional expenditure. So, token grant does not involve additional grant or additional money to be drawn from the that is, you can say, from the Consolidated Fund of India. It is does not involve additional grants, additional expenditure. That is also a point to be remembered. So, apart from the budget, we have seen that there are many grants approved by Parliament for the executive to meet. These are all financial control mechanism of the Parliament. So, this is how the Parliament exerts financial control over the over the executives. Okay. Now, we shall move to the multifunctional role of the Parliament. So, Parliament functions, we have discussed the multifunctional roles of the Parliament. Okay, we shall discuss. Okay. So, we shall discuss the multifunctional role of Parliament. As we have already discussed and we have gathered a lot of discussion on Parliament, you must have seen that Parliament functions a variety of functions. It is not merely a legislative body, but it has certain other functions. It is the supreme legislative body in the country, and apart from legislative functions, it also performs executive functions, financial functions, constituent power functions, judicial functions, electoral functions, and other also functions are there. So, it is a multifunctional body. In legislative functions, Parliament is the supreme law-making body in the country, and it has the authority to legislate on union list and state concurrent list. It has more extensive power to or plenary powers of legislation on the subjects mentioned in the union list and concurrent list, but Parliament can also legislate on state list in certain circumstances. There are 5 circumstances in which the Parliament can legislate on state list. So, parliamentary legislation parliamentary legislation on state on legislation on state list, that is when Rajya Sabha passes a resolution, under Article 249 Rajya Sabha passes a resolution that it is essential to make a law or make a legislation on the subjects mentioned in the state list under Article 249, then it will be prudent for the parliament to go for that. That is also a point. Next, number 2, when national emergency is in operation, so it is required when the national emergency is operation, parliament can legislate on any matter enumerated in the state list for the larger national interest under Article 250 probably. Next, number 3, when two or more states make a request, so it can be also a ground for legislation by the parliament on the state list if some states make a request to the central government to make a common law on any specific matter like agriculture. We have Farmers Act, so that is agriculture is a state subject, but the central government has legislated on the farmers benefit, has legislated Farmers Act because of the request, because maybe there may be request. So for that is number 4. And then number 4, to give effect to international agreements, so if it is required, then parliament can make legislation on the state list. And number 5, president's rule. When the president's rule in operation, president's rule is in the state, then the state legislative assembly may be dissolved or may be kept under suspended animation. That means during the president's rule, the state legislative assembly becomes dysfunctional and not in a position to legislate on the matters on the state on the list. So at that point of time, if it is required, then parliament can make legislation on the state. So look at the 5 grounds on which parliament can legislate on the state list. So this is why this is called the legislative power, and even if there is also the parliament can delegate the legislative power to the parliament, because parliament passes skeleton format and leaves the matter to executive, that is called delegated legislation. So delegated legislation is a common trend or a modern trend practiced in parliament all over the world, in almost all parliament. In Indian parliament also delegates certain powers to the executive due to lack of expertise and due to lack of time. So that is called delegation of legislation, when parliament delegates the onus of drafting a bill or making a legislation. That is called delegated legislation. But it does not mean that parliament abdicates the responsibility for the legislation. Ultimately, parliament holds the responsibility for the legislation, even if the legislative power is delegated. So, delegated legislation is also a very common trend, common practice in the present context in Indian Parliament. Considering the nature of time, considering the nature of development that is taking place in the country due to rapid development in the field of science and technology, certain aspects, certain types of matters have become so complicated and technological that it is not in the purview of the capacity, it is not within the capacity of the Parliament to understand the tidbits. Hence, there is a need for delegated legislation. But remember, in delegated legislation, there is no complete abdication of responsibility. Okay, the Parliament is understood. That is the things. Apart from that, the ordinances also a part of executive legislation. Sometimes executive is empowered to issue ordinances when the Parliament is not in session. But ordinance is not a parallel making power of the executive. Such ordinances issued by or promulgated by the President must have to be approved by Parliament within 6 weeks from the date of reassembly, otherwise the ordinances will lapse. So, these are the parts of or the features of legislative power of the Parliament. It performs extensive legislative powers in a parliamentary arrangement. Then it has also executive powers and functions. Parliament, in a parliamentary democracy, executive is collectively responsible to Lok Sabha. It means the executive will continue to rule the country or to govern the country as long as it has confidence of the House, means as long as it enjoys comfortable majority in the House. If the Parliament also exerts controls over the executive through various mechanisms, through passage of budget, through passage of that is your known, that is money bill, and the passage of the act, any amendments, everything has to be passed by the Parliament. So, Lok Sabha can show its disapproval or lack of confidence in the executive through various means, by not accepting or not approving the motion of thanks, by rejecting the money bills, by disapproving the budget, by passing the court motions, by passing the no confidence motions. So, there are various ways, various methods for exerting control over the executive, and executive is held responsible for that part of the things. The function of Parliament can be said to be the select the group which is to form the government. And another thing, that it is the Parliament which selects the government. The legislative party of the Parliament is that is called the ruling party. The largest legislative party is called the ruling party, and the ruling party are the members of the Parliament, and out of them one member is chosen as the Prime Minister, and some others are chosen as ministers. That means under a parliamentary dispensation, executives are integral part or members of the Parliament. That is also a part of the executive power, executive functions of the Parliament, and it exerts lot of support, lot of control over them. Then financial powers. The no tax, it is provided that the custody of the consolidated fund of India, in which the income of the government is deposited, the entire money that is spent in, that is deposited in the consolidated fund of India, and the consolidated fund of India is under the custody of the Parliament. So, no tax can be levied, or no money can be spent without the approval from the consolidated fund of India, without the approval of the Parliament. So, it is the Parliament which releases money required by the government to spend. In this way, the Parliament exerts extensive financial control over the executive through the passage of the budget, through the passage of the money bill, through the passage of the financial bill, every monetary bills. There is a special provision of money bills also. So, no money, no tax can be levied without authority of law. That means the executive cannot impose tax on its own. Such tax measures has to be approved by the Parliament. In this way, Parliament exerts extensive financial control and enjoys extensive financial powers in a parliamentary dispensation. That is called the parliamentary executives. Then your constituent powers, parliament is vested with the powers to amend the constitution. So constituent power is a very unique power in the hand of the vested in the legislature. The constitution, and there is a constitutional supremacy in India. So constitution is the fundamental law of the country, and any change in the constitution is the ultimate authority of the parliament. No other institutions, no other body can bring any amendment in the constitution. The parliament enjoys the plenary amendment power, amending power related to the constitution. Parliament can amend the constitution in various ways, by just having a simple majority and by special majority, and also in certain matters the parliament has to seek, the states are consulted, and half of the state consent is required for passage of the amendment bills. So constituent powers the constituent power means the power of amendment to constitute, to amend the constitution, and amendment may involve addition, deletion and substitution. Parliament can amend any part, parliament can amend any part by adding some few provisions. Parliament can amend the constitution by abolishing some provisions. Parliament can amend the constitution by substituting some provisions. So addition involves addition, amendment involves addition, deletion and substitution. That is also variations can also take place. And constitution can be amended in three different ways, as I told you: by simple majority, by special majority and by special majority with approval of the half of the states in certain matters. But in whether the amending power of the parliament is absolute or not, that question was debated as largely in the Supreme Court. In some cases, it was perceived that by 24th Amendment Act 1971, the parliament amended the provisions and said that the amending power of the parliament is absolute. But in Kesavananda Bharati case 1973, the Supreme Court held the opinion that the amending power of the parliament is no doubt related to any part, any provision of the constitution, but subject to the basic structure. Parliament cannot amend any provision by way of destroying the basic structure or basic features of the constitution, and accordingly the Supreme Court has added many provisions as basic structure of the constitution. For example, parliamentary democracy is a basic structure of Indian constitution. It means the parliament cannot amend the constitution so as to provide, or with a view to providing a presidential arrangement. It is not possible. Hence also fundamental rights are basic structure, secularism is a basic structure, and judicial review is a basic structure, and there are various factors, that is the various provisions have been accepted as basic features of the constitution, and the Supreme Court has said it that parliament's amending power is not related to destroying the basic structure. So we can say that the amending power of the parliament as per the present scenario is not absolute in nature. It can bring change, it can amend the constitution, no doubt, but it cannot amend to that extent which will violate the basic structure of the constitution. Hence it is as extensive, that is called extensive, amending power. That is the constituent power or constituent power. Then judicial functions. Although parliament is not a judicial body, it is primarily a legislative body. It has also certain judicial functions or similar functions pertain to judicial functions. Parliament functions certain judicial functions, and accordingly it has also called it has certain judicial powers. The judicial powers involve that the impeachment of the president. Impeachment of the president is a quasi-judicial procedure, because during the process the parliament takes up investigation of the allegations against the president. So impeachment of president under Article 61 the procedure is called a quasi-judicial procedure, because Parliament being a legislative body takes up investigation of the cases. Then impeachment of the judges also, impeachment of the judges are also also a judicial function of the Parliament. It is also related to the removal of the High Court Vice President, and it can punish members and outsiders for breach of its privileges. It is also a judicial functions. So judicial functions involves impeachment of the President, removal of Supreme Court and High Court judges, Chief Justice of India, Comptroller and Auditor General, Chief Election Commissioner and others. Removal of the Vice President is also a judicial function, and also the punishment of members and outsiders for the breach of privileges. There are certain privileges of the Parliament, collective privileges of the Parliament, and that must not be broken, that must not be violated. So in case a person is guilty of breach of privileges of the Parliament has the authority to punish the person, or whether he is a member or an outsider, that doesn't matter. So these are called the judicial powers of the Parliament, judicial powers. Then electoral powers. Parliament is an elected body, mostly Rajya Sabha and Lok Sabha are elected body. It is elected indirectly and directly by the people also. Most of the members, 99% of the members of the Lok Sabha are directly elected, and also a considerable number of members in Rajya Sabha, near about that is total 233 members are indirectly elected. And as it is an electoral body, it is completely an elected body, and as it is an elected body, it also functions certain electoral functions, that it elects the Speaker and the Deputy Speaker, and also elects the Chairperson of Rajya Sabha, that is Vice President, and also elects the Deputy Chairperson of Rajya Sabha. So this is called electoral functions, and authorized to make laws and regulations of elections, and Parliament is there to make rules and regulations for the election process in the country. So it is also related to, it has enacted Representation of People's Act in different years, 1950, 52, and Vice Presidential Election Act 1952, Representation of People's Act 1950, Representation of People's Act 1951 have been enacted by the Parliament, which is related to elections. So Parliament has certain electoral functions, that is called electoral functions. Apart from that, it also has some that is the other functions, other powers. It is the highest deliberative body in the country. It discusses various issues of national and international significance. It approves the three types of emergency also. The three types of emergency, that is national emergency, financial emergency and state emergency, are to be approved by Parliament under the specified provisions. It can create and abolish a state legislative council after the approval of the resolution by the state legislature. It can also pass a act for the abolition or creation of the things of the state legislative council. It can increase or decrease the area, the boundaries, and change the names of state and Indian Union. So Parliament has the ultimate authority in changing the political map of India. That is also a unique power of the Parliament. And for this purpose, India is called indestructible union with destructible states. So the changing political map of India is the authority that is vested in the Parliament. It also comes under other functions, and regulate the organization and jurisdiction of the Supreme Court and High Courts, and it also can establish a common High Court for two or more states. That is called the other functions. So these are the certain functions that we have taken briefly. So kindly remember that Parliament is a multifunctional body, and it functions multifunctional roles. So the importance and significance of Parliament in a parliamentary arrangement is second to none, and therefore the inevitability of Parliament supremacy or parliamentary sovereignty cannot be denied. It should be made more representative. It should be made properly representative, and the the institution should be strengthened enough to face the challenges of the present time. That is the message that you can send through the discussing the multifunctional role of the parliament. Now, we shall move to the sovereignty of parliament. Sovereignty of the parliament. Sovereignty of the parliament is means the supreme legacy of the supreme authority of the parliament. No doubt कि parliament is a sovereign body, a sovereign institution of legislation institution, law making institution in the country, and it has the supreme power of legislation. But Indian parliament is not as sovereign as British counterpart, as its British counterparts. It is not as sovereign as British parliament. The British parliament is parliamentary enactments, British parliamentary provisions are not subject to judicial review. Hence, British parliament is the supreme, or the you can say that absolute institution in the system. But in Indian case, Indian parliament is not as sovereign as British parliament, because the parliamentary enactments or enactments passed by the parliaments, whether amendments or whether any ordinary bills or anything that are enacted by the parliament are subject to judicial review by the Supreme Court. So, the sovereignty or the sovereign power of the parliament are restricted in various manners. The written nature of the constitution also restrict the sovereignty of the parliament. In case of the UK, you will find an unwritten constitutions. That means the powers of the executive, legislature and other organs are not well defined in the British constitution. The constitution or the political system runs on the established parliamentary conventions and enactments. But in Indian case, the political system runs on a written constitution, on the basis of a written constitution, and the constitution has well defined the powers and functions of each organ of the government in a clear cut manner. So, there is no chance for any legislature, any organ to supersede the other, or to ignore the others, or to dominate the system. So, neither judiciary nor the legislature is superior, that is constitution is superior. Everybody is bound within the limits prescribed by the constitution. So, hence the written constitution, written democratic constitution restrict or limit the sovereign or the absolute powers of the parliament and putting it under the fold. That in what way? Because the parliamentary enactments can be subject to judicial review, and that is also written nature of the judicial review, and parliament's status or parliament's provisions, powers that can be written or deleted from the constitution. So, for this reason, parliament is not as sovereign as the British counterpart. It is because of the limited nature of the constitution. Then federal system of government. Federal system of government also diminishes the sovereignty of the parliament. In a federal type of government, there is a division of power between the state and the central government, the federating government, and there is a division of power between the federation and the federating units. In 7th schedule of the constitution, the 3 lists suggest or indicate the division of powers. So, as some of the powers are kept in the state list, and in which the state legislature are the authority to legislate, the power of the parliament to legislate on the state list is restricted, though it can legislate on the matters in the state list, but in certain circumstances, as we have just taken in note, in what circumstances parliament can make legislation or bring legislation on the subjects mentioned in the state list, and that is the point to be noted. Although parliament can legislate on the state list, but the timing is but the circumstances are quite limited. That means parliament cannot always legislate on the state list. So, the powers are diverted, are taken away from the parliament or from the union legislature to legislate on certain aspects that are prerogative of the state legislature. In this way, the federal system of government also diminishes the ultimate sovereignty or the absolute sovereignty of the Indian Parliament. Had it been a unitary country, the sovereignty of the Parliament or the power of the Parliament would have been multiplied. That is also a point to be remembered. Then in a system of judicial review, as I was talking about, that the parliamentary enactment are not absolute in nature. Whatever laws are enacted by the Parliament or amended by it are subject to judicial review. Judiciary has the power to ensure that laws made by the Parliament are in accordance with the Constitution and they do not violate the fundamental rights, and they are enacted or they are made by competent authority. What I mean to say that the judicial power or judicial power of judicial review vested in the Supreme Court is though limited, but it has lasting impact on the sovereignty of the Parliament. That means Parliament enacts such laws and keeping in view or keeping in mind the supremacy or the situation of Supreme Court or the presence of the Supreme Court, it must be taken into consideration by the Parliament while acting any enactment or amending any part of the Constitution, because those laws, those changes, those amendments will be put forward before the Supreme Court for review, and Supreme Court can make it that may reject or declare an enactment of Parliament ultra vires. In many cases, Supreme Court has made or has declared parliamentary enactments as ultra vires. Recently, you must have seen that Parliament was bound, executive Parliament was bound to repeal the Farmers Act because of the pressure from the judiciary and from the civil society. So, parliamentary enactments are subject to judicial review, and that restrict the power of the Parliament. Okay, that is also a point to be remembered, that how it protect the Parliament. Then your fundamental rights. Fundamental rights are that is, you can say, protection of individual liberty against state encroachment. Parliament cannot legislate, make legislation or bring legislation on any matter, any subject matter which will violate, or any change, any enactment that which will violate fundamental rights. So, Parliament cannot legislate, cannot make enactment that will violate fundamental rights of the people of the country. So, fundamental rights limit the power of the government. It promotes limited government. Hence, it also that means it limits the sovereignty of the Parliament, because Parliament cannot be arbitrary in this respect, cannot be monopolistic in this respect. Whatever laws are made by it, whatever enactments are made by it, whatever amendments are made by it, that changes, that amendments, that enactments must be in consonance with the Constitution, must be in accordance with the Constitution. That should be, and must be in accordance with the fundamental rights, must not violate them, because fundamental rights are basic human rights and they are specially protected by the Constitution. And therefore, Parliament has to take these rights into consideration while making laws. That is also a provision you have to remember. So, fundamental rights also compromises the power of your Parliament to legislate. So, these are the factors which are responsible for limiting the sovereignty of Parliament. But remember, despite certain limitations which must be there also, one must not be absolute in its approach, one must not be made an absolute institution, because absolutism or absolute arrangement, absolute institutionalization is much against the interest of democracy. So, no institution, whether legislature or executive or judiciary, be an absolute one in the larger interest of democracy. Hence, it is essential. But despite limitations, Parliament has ample scope, or is provided or is assigned with an extensive scope to legislate and to be a highest deliberative body defining the national objectives and national goals. Okay? Therefore, the sovereignty of the parliament is just a objectively can be analyzed, and it is vital in this respect. Okay? So, that is sovereignty. Okay? Then we shall move to the that is your comparative position of Rajya Sabha and Lok Sabha. As we have reduced the time length for 1 hour from 12 to 1 from these sessions onward. So, we will have limited discussion on specific chapters. So, this chapter I am leaving it to the next class. In the next class we shall complete this part, because we are having 1 hour class. So, in this 1 hour class we shall complete as much portion as possible. So, in the next class we shall be starting with comparative position of Rajya Sabha and Lok Sabha, and we shall see in what respect Lok Sabha has exclusive authority, in what respect Rajya Sabha has exclusive authority, and in what respect they differ from each other, whether who is superior, whether Lok Sabha is superior or Rajya Sabha is superior. But the common perception that Rajya Sabha is inferior is a myth. Rajya Sabha is not an inferior chamber, it is assigned with the task which is not assigned to the Lok Sabha. So, it is a chamber that is irreplaceable. Okay, we shall discuss more about it, and then we shall discuss the aspect of parliamentary committees. We have to give a short note on that. Parliamentary committees, then other committees are there. So, apart from the committee, then we will come to the MCQ part. Okay. So, keep watching our classes and have your constructive comments on the nature of the classes, or any suggestion for improvement in the procedure of taking classes, or any other suggestions related to the class. You can make it and bring it to our knowledge. We will definitely work on that. Till then, so we shall come face to face in the next class. Till then, I bid you goodbye and wish you all the best in all your future endeavor. Stay protected, and keep watching Banik YouTube class on civil service examination. Thank you very much.